It's not the corporate death penalty, but it could be the death of Donald Trump's bank account. Judge Engeron in New York State Court has ordered Donald Trump to disgorge, that is, pay hundreds of millions of dollars as a penalty for years of malfeasance. And for reasons we'll discuss, he might be on the hook for almost $500 million.
A crooked New York State judge just ruled that I have to pay a fine of $355 million for having built a perfect company. Great cash, great buildings, great everything.
Now, Judge Engeron starts his decision by noting that the common law fraud rules in New York made it far too easy for crooks to get away with fraud. Quote, in mid-20th century New York, to judge by contemporary press reports and judicial opinions, fraudsters were having a field day. So by the 1960s, New York decided to pass a law replacing common law fraud. That law grants the Attorney General the authority to seek an injunction against anyone who engages in repeated fraudulent or illegal acts or demonstrates persistent fraud or illegality in business transactions, to seek disgorgement of ill-gotten gains, to impose bans on individuals doing business in the state, and even to cancel business certificates. Now, Judge Engeron took judicial notice of the fact that New York City is one of the financial capitals of the world, and as such, the state of New York has an interest in an honest marketplace. Trump supporters, taking their cue from Trump himself, often say that everybody lies on their financial statements. That's just how it goes, and as long as he paid back the loans, then no harm, no foul. But Judge Engeron took offense to that characterization. Quote, timely and total repayment of loans does not extinguish the harm that false statements inflict on the marketplace. Indeed, the common excuse that everyone does it is all the more reason to strive for honesty and transparency and to be vigilant in enforcing the rules. Here, despite the false financial statements, it is undisputed that defendants have made all required payments on time. The next group of lenders to receive bogus statements might not be so lucky. New York means business in combating business fraud. And with that out of the way, the judge summarized what had already happened. And we've talked about this at length on this channel. In a decision and order dated September 26, 2023, the court granted the state summary judgment on liability solely for the first cause of action. The judge determined that Trump's main defense, that his statements of financial condition contained disclaimers and a worthless clause, did not shield defendants from liability for their material misrepresentations. The judge found that the Trump financial statements materially misrepresented the value of various properties, and the court ordered the cancellation of defendants' business certificates under General Business Law Section 130, the so-called corporate death penalty. Although the appellate division temporarily halted this cancellation pending the outcome of defendants' appeal of the summary judgment rulings. The judge then held a 44-day trial to decide the remaining causes of action, alleging illegality under Section 6312 by falsifying business records and financial statements, committing insurance fraud, and conspiracy to commit those acts. And as you probably know by now, the trial did not go well for the Trump defendants. The judge's verdict first reviews the highlights and lowlights of the witness testimony. Donald Trump's testimony demonstrated that he signed off on all of the financial statements, the SFCs, and sometimes offered his opinion on specific issues. Judge Engeron said that Trump frequently made wild claims. For example, he testified that he actually undervalued Mar-a-Lago, believing it is currently, quote, worth more than the most expensive private residence listed in the country by approximately 400%. There's no possible way that Mar-a-Lago, with its deed restrictions that last in perpetuity, is the most expensive property in the United States. The judge also considered an audio tape of Trump saying that 40 Wall Street was 72 stories tall when it was in fact only 63. Quote, when asked if he was misquoted in the Forbes article, Donald Trump replied, I don't know what I said. The judge went on, overall, Donald Trump rarely responded to the questions asked, and he frequently interjected long, irrelevant speeches on issues far beyond the scope of the trial. His refusal to answer the questions directly, or in some cases at all, severely compromised his credibility. So it turns out that you can only be a terrible witness on the stand for so long before people start noticing, and it hurts you in the judgments. The judge has already dismissed claims against Ivanka Trump because she was not involved in the preparation of the financial statements. Ivanka testified during the trial, but the court didn't find her terribly persuasive. Quote, on direct examination by plaintiff, Ivanka Trump had no recollection of any of the events that gave rise to this action. No number of emails or documents with her signature served to refresh her recollection. Notably, on cross-examination by defendant's counsel, Ms. Trump suddenly and vividly recalled details of the projects and her interactions with Vrablic. For example, after testifying on direct examination that she could not recall any of the details of her father's personal guarantee of the old post office loan, on cross-examination, she suddenly recalled, quote, there was a step down of the guarantee, if I recall, once the property was operational. Ivanka Trump was a thoughtful, articulate, and poised witness, but the court found her inconsistent recall depending on whether she was questioned by OAG or the defense suspect. In any event, what Ms. Trump cannot recall is memorialized in contemporaneous emails and documents. In the absence of her memory, the documents speak for themselves. As for Trump's nemesis, Michael Cohen, the court found him credible on some things, but also very skeptical at the same time. Quote, Michael Cohen was an important witness on behalf of the plaintiff, although hardly the linchpin that defendants have attempted to portray him to be. His testimony was seemingly compromised by his having pleaded guilty to perjury and by some seeming contradictions in what he said at trial. However, carefully parsed, he testified that although Donald Trump did not expressly direct him to reverse engineer financial statements, he ordered him to do so indirectly in his mob voice. Although the animosity between the witness and the defendant is palpable, providing Cohen with an incentive to lie, the court found his testimony credible based on the relaxed manner in which he testified, the general plausibility of his statements, and most importantly, the way his testimony was corroborated by other trial evidence. Again, with most high-stakes litigation, it's the documents that are really telling the story. The court called out Don Jr. for claiming that the Trump Organization, which he runs, filled the CFO position after Alan Weisselberg left. Quote, the role of CFO has remained vacant ever since, a fact that Donald Trump Jr. did not know at trial, mistakenly believing that Mark Hawthorne was the new CFO. The court heard from many expert witnesses. Michael Bacardi was the state's main witness. His, quote, calculations determined that Donald Trump improperly saved the following amounts on interest as a result of the banks relying on Donald Trump's fraudulent SFCs and personal guarantee, and went on to list $72 million from the Doral golf course, $53 million from the old post office hotel loan, $17 million from the Chicago building loan, and $24 million from 40 Wall Street. And the judge determined that McCarty's methodologies were sound and accepted his conclusions, in part because Trump's expert witnesses were not great. Most of the Trump experts declined to give their opinion on whether the valuations were correct. One expert, Gary Giulietti, turned out to have a financial interest in the case. Giulietti is a close friend of Trump's who golfs and dines with him and is a member of many of his golf clubs. He's also Trump's insurance broker. Judge Engoron said, the quote, in its over 20 years on the bench, the court has never encountered an expert witness who not only was a close personal friend of a party, but also had a personal financial interest in the outcomes of the case for which he is being offered as an expert. Giulietti's testimony was also wild because it insisted that a company like Zurich would never bother looking at statements of financial condition. He claimed that Zurich would only consider liquidity. He claimed that Zurich's underwriting was based on airballs and witchcraft. Of course, Giulietti's testimony was contradicted by a person who actually worked at Zurich and one of Trump's own expert witnesses. Judge Engoron also had harsh words for Professor Eli Bartov of NYU. Although Bartov did not assess the valuations of any of the assets on Donald Trump's SFCs, he still claimed that, quote, the statements of financial condition were accurate in every respect, and they were 100% consistent with GAAP.
He's one of the most respected people anywhere in the country for doing this kind of thing, expert wisdom. He said, this is one of the greatest financial statements I have ever witnessed before.
But the court stated, quote, as this court discussed in excruciating detail in its September 26, 2023 decision and order, the SFCs contain numerous significant errors. By doggedly attempting to justify every misstatement, Professor Bartov lost all credibility in the eyes of the court. Indeed, Bartov insisted that the misrepresentation of the triplex, resulting in a $200 million overvaluation, was not intentional or material, leading the court to wonder in what universe is $200 million immaterial. Now, if you have defrauded the state of New York for decades, you're gonna need a good lawyer. But if you want a great lawyer, my firm, the Eagle team, can help. If you've had an injury or death in the family, or had a data breach, especially if you got one of those data breach letters, or were involved in a car crash, we can represent you or help find you the right attorney. It's so important to talk to a lawyer early in the process to learn what your options are and maximize your recovery. So just click on the link in the description for a free consultation with my team, because you don't just need a legal team, you need the Eagle team. The link is down below. And the judge found that the Trump defendants engaged in systematic deceptive practices to inflate the value of the assets on their SFCs. Quote, Trump told Weisselberg that he wanted his net worth on the statement of financial condition to go up. Continuing, to ensure the net worth went up between 2011 and 2015, Weisselberg and Michael Cohen were tasked by clear implication from Trump to reverse engineer the various different asset classes in the SFCs to increase those assets in order to achieve the number, Trump's net worth figure, that he told them to reach. Once Weisselberg and Cohen achieved the number that Trump tasked them to reach, Weisselberg would obtain Trump's approval and send the SFCs to Mazars for finalization. Now, it should go without saying, this is not how statements of financial condition are supposed to work. You don't begin with a number you want and then manipulate the assets to reach the valuation that you're looking for. Judge Engoron found that, quote, there is overwhelming evidence that Alan Weisselberg intentionally falsified hundreds of business records during his tenure as CEO of the Trump Organization. Weisselberg understood that his assignment from Donald Trump was to have his reported assets increase every year, irrespective of their actual values. Judge Engeron concluded that, quote, the examples of Weisselberg's intent to falsify business records are too numerous to itemize. And as Liz Dye over at Law and Chaos points out, once the Trump org was being monitored and was required to provide accurate financial statements, they just stopped providing them. So the court concluded that they could not provide accurate statements. And when Trump became president, he appointed Eric and Don Jr. as his agents with power of attorney over banking and real estate. They, along with Weisselberg, were responsible for preparation of the SFCs from 2017 through 2021. Quote, there is also sufficient evidence that Donald Trump Jr. and Eric Trump intentionally falsified business records. They served as attorneys in fact for Donald Trump and were under a heightened duty of prudence. Don Jr. argued that he didn't read the SFCs closely, but the law presumes that Jr. read and understood the contents of his representations. The court also inferred Don Jr.'s intent to defraud by his acknowledgement that third parties could rely on his representations. And although the state said that Trump inflated his numbers to make himself look more wealthy, Trump has repeatedly said that he actually undervalued the properties. But undervaluing the properties is also problematic, especially when you're saying different things to different people depending on who they are. Now, the state claimed that, quote, Donald Trump and his trustees falsely and misleadingly classified his 30% interest in cash held by the Vornado partnership interest as a liquid/cash asset on his SFCs for 2013 through 2021 in amounts between $14,221,800 and $93,126,589. Now, this was a major problem because the Trump defendants frequently claimed that lenders and insurance underwriters only cared about his liquidity, but his liquidity was also suspect. Trump apparently listed this cash in the asset category even after Trump's personal accountant, Donald Bender, told him he couldn't include any cash that Trump did not control. Quote, neither Donald Trump nor the Trump Organization could access his interest in any of the assets in the partnership without Vornado's consent. Mark Hawthorne, who ran Trump Hotels, even said that including the Vornado cash in the cash asset category was a red flag and a very glaring issue. Then there is Trump's famous triplex in New York. Quote, for 2012 through 2016, defendants used a false figure for the size of the triplex of 30,000 square feet, or approximately 3 times the apartment's actual size. And apparently Trump calculated the value per square foot by using the asking prices of similarly sized apartments rather than the actual sales prices of the properties. Everyone knew the true size of the triplex because in 1994, Trump signed a statement confirming it was only 10,996 square feet. Nevertheless, Weisselberg insisted that it was over 30,000 square feet, and even Forbes caught on to this fraud. Quote, on February 22nd, 2017, Forbes magazine emailed Weisselberg and McConey to question the 30,000 figure the Trump Organization used for the triplex's size because public records showed that it was only 10,996 square feet. When Forbes asked Trump's counsel, Alan Garten, about the triplex, he forwarded the email to Eric, Don Jr., and Weisselberg, and they decided not to amend the statements of financial condition. In fact, just 4 days later, they finalized the 2016 SFC with Mazars, stating that the value of the triplex was accurately assessed as if it were 30,000 square feet. In 2017, the SFC contained the correct square footage, but the Trump defendants decided to add a presidential premium, which would maintain the overall value of the triplex. Then there was the building at 40 Wall Street. Quote, from 2011 through 2016, McConey and Weisselberg valued 40 Wall Street based on dividing net operating income by a capitalization rate, but rather than using the actual appraisals of 40 Wall, McConey used cap rates from a generic market report. When preparing the SFC, McConey cherry-picked a cap rate of 3.04% and excluded the pages of the actual appraisal of 40 Wall, which had a cap rate of 4.25%, which resulted in an appraised value that was $227 million lower than McConey's value. Jeffrey McConey, who was high up in the Trump Organization, played all sorts of games to justify the valuation, such as double counting the value of a lease signed by Dina DeLuca. And the upshot of this is that the Trump Organization claimed it ran a $26.2 million net operating income on 40 Wall Street, but in reality, it was a deficit as high as $20.9 million through 2015. There's been a lot of controversy surrounding the Seven Springs property. Eric Trump was personally involved in the inflated value of the Trump Seven Springs resort. The court concluded that the state had proved that Eric knew that an appraisal by Cushman & Wakefield estimated the total value of the property's undeveloped lots was between 30 and 50 million. However, Trump's 2014 financial statement valued the property at 291 million, including 161 million for just 7 of the undeveloped lots. The court concluded that the state had proved that Eric knew that an appraisal by Cushman & Wakefield estimated the total value of the property's undeveloped lots was between 30 and 50 million. However, Trump's 2014 financial statement valued the property at 291 million, including 161 million for just 7 of the undeveloped lots. And that takes us to Mar-a-Lago. We've covered the Mar-a-Lago valuation in detail in other videos, but here's the bottom line. Between 2011 and 2021, the, quote, defendants valued Mar-a-Lago based on the false premise that the property could be sold as a private residence when years earlier, Trump conveyed his rights to develop Mar-a-Lago for any usage other than commercial usage as a club. The court continued, in exchange for executing the 2002 deed in which he gave away in perpetuity the right to develop or use the property as a single-family residence, Donald Trump paid significantly lower property taxes on Mar-a-Lago. Trump's position is basically that he can get out of the deed restriction if he wants to. However, the judge concluded that, quote, there is no legal gray area surrounding the permanent nature of the deed restrictions. Accordingly, there can be no mistake that Donald Trump's valuation of Mar-a-Lago from 2011 through 2021 was fraudulent. Now, the full decision goes through errors related to several other properties, but let's move on to the issue of intent because that is pervasive throughout all of these charges. The state proved that Trump did not assess his net worth based on his assets. Instead, he set a desired target for his net worth and then manipulated the valuations to hit the target. Trump took great offense to the concept that the New York executive law doesn't require a traditional victim. Now, Trump continually argued that there was no victim, so there can be no crime, but this is incorrect as a matter of law.
Just so you know, my financial statements are phenomenal. They are actually less in terms of the numbers used than the actual net worth. The actual net worth is substantially more. No bank was affected, no bank was hurt. They don't even know why they have to be involved.
The state of New York, quote, has an interest in protecting the integrity of the marketplace, and the banks did lose money by lending at a lower interest rate than they otherwise would have. Moreover, many witnesses actually did testify that they relied on the SFCs. A former Deutsche Bank risk management officer testified that Trump's statements of financial condition were key to his approval for a $125 million loan in 2011 for his golf course resort in Doral, Florida, and a $107 million loan in 2012 for his Chicago hotel and condo skyscraper. The former Deutsche Bank employee said that those numbers helped Trump secure bigger loans and lower interest rates. Several insurance underwriters also testified that they relied on Trump's SFCs, most importantly, the inflated cash figures when they completed their analyses. And the state's claims did not require proof that a third party relied on the fake numbers to their detriment. But the question was, did Trump himself know what was happening and did he intend for it to happen? Judge Engoron said yes, quote, Donald Trump was aware of many of the key facts underpinning various material fraudulent misstatements in the SFCs. He was aware of having deeded away the right to use Mar-a-Lago as anything other than a social club, and notwithstanding, continued to value it as if it could be used as a single-family residence. He was aware that the triplex apartment in which he, a real estate mogul and self-identified expert, resided for decades was not 30,000 square feet, but actually 10,996 square feet. He was aware that he did not control the Vornado partnership interest, even though he represented it as cash. He was aware that he had permission to build only 500 private residences in Aberdeen, notwithstanding that he represented that he had permission for 2,500. And he was aware that 40 Wall Street was operating at a deficit, despite proclaiming that it was running a net operating income of $64 million. As Eric Trump testified, Donald Trump sat at the top of the pyramid of the Trump Organization until 2017. Donald Trump professed to know more about real estate than other people, and to be more expert than anybody else, he repeatedly falsified business records with the intent to defraud. So the judge found all defendants liable for conspiracy to commit insurance fraud. Quote, although only Alan Weisselberg and Jeffrey McConey performed the overt acts of the insurance fraud, all defendants are liable for the conspiracy, as only an overt act by one of the conspirators in furtherance of a conspiracy is needed to be shown. And since each of the defendants participated in aiding and abetting the conspiracy to commit insurance fraud, quote, causing material fraudulent SFCs to be intentionally submitted to insurance companies, Judge Engoron ruled that the defendants had to return their ill-gotten gains. This is known as disgorgement. Disgorgement typically refers to a remedy or penalty imposed by a court where a defendant is required to give up the gains obtained through illegal or wrongful conduct. So here's a pie chart showing what the state asked for, approximately $370 million in ill-gotten gains. And the judge accepted most of the calculations of the state's expert witnesses about how the defendants gained financially by securing loans from Deutsche Bank's private wealth management division. The fraudulent SFCs resulted in reduced interest rates compared to the rates they would have incurred as a result of accurate SFCs. And as a result, the Trumps now have to pay back hundreds of millions of dollars. The court also concluded that there is significant evidence that Alan Weisselberg's $2 million separation agreement was arranged to compensate him for his ongoing refusal to cooperate with any of the entities that are investigating or prosecuting the Trumps. And additionally, given Weisselberg's central role in nearly all instances of fraud, Judge Engoron found it would be unjust to allow him to profit from his actions. Weisselberg is accountable for the funds that he has obtained through his separation agreement, as they're considered to be unjustly acquired gains. And despite being promised a total of $2 million, Weisselberg had only received $1 million at the time of his testimony. Therefore, Alan Weisselberg is going to have to surrender the $1 million that he's already received. And here's a pie chart showing how Judge Engoron ruled. As you can see, it's remarkably similar to what the state asked for. And on top of that, the defendants must also pay pre-judgment interest in a case like this that adds a significant amount to the total. Unfortunately for Donald Trump, quote, a defendant's corrupt intent or desire for personal profit is a factor to be weighed in the court's exercise of discretion. And in New York State, in a case like this, prejudgment interest is simple 9%, meaning it doesn't compound, but it's 9% from the time that it starts to run. And here the court set the prejudgment interest running from 2019. So that's going to add tens of millions of dollars to what Trump ultimately has to pay if this verdict holds up. Now, additionally, an attorney general who has demonstrated, quote, repeated illegal or fraudulent acts may obtain injunctive relief pursuant to the executive law at issue here. And apparently the judge was looking for evidence of contrition, but found none. And compounding that, the judge found that they seldom complied with court orders. The Trump defendants were required to report all of their goings-on to independent monitor Barbara Jones, a former federal judge. But Judge Jones said they continued to hide things, including a $50 million loan that might actually be fake. And Jones's reports convinced Judge Engoron that, quote, defendants' refusal to admit error, indeed to continue it, according to the independent monitor, constrains this court to conclude that they will engage in it going forward unless judicially restrained. So the court permanently enjoined Alan Weisselberg and Jeffrey McConey from serving in the financial control function of any New York corporation. Donald Trump himself was banned from serving as an officer or director of any New York corporation for a period of 3 years, and Eric Trump and Don Jr. were banned for 2 years. And one thing that could really hurt them as a going concern is the court banned the group from seeking a loan for 3 years.
They want me out. Oh, let's see if we can get them out.
But that doesn't mean that Trump lost everything. His biggest win was the judge vacating the order to dissolve the business licenses. That order was stayed on appeal, and if the judge had gone through with it, then the Trump businesses would presumably have to be liquidated. But the judge decided against that for now. Quote, however, as going forward, there will be two-tiered oversight, an independent monitor and an independent director of compliance of the major activities that could lead to fraud. Cancellation of the business licenses is no longer necessary. Accordingly, this court hereby modifies its September 26, 2023 decision and order solely to the extent of removing the language ordering the LLC's cancellation en masse. The restructuring and potential dissolution of any LLCs shall be subject to individual review by the court-appointed independent director of compliance in consultation with Judge Jones. So Judge Engoron reserved the right to dissolve the licenses later if necessary. The court-appointed independent monitor Barbara Jones now has more power though. Now the Trumps cannot do anything with the businesses without her prior approval. He gave Jones 30 days to submit a proposed order with everything that she thinks is necessary to, quote, keep defendants honest. The judge also ordered the Trumps to appoint an independent director of compliance who will report to Jones, and Judge Jones will be in charge of selecting this person. And why did the judge impose such strict injunctive relief? Because, quote, this is not the defendant's first rodeo. You might recall in 2013, the Trump organization paid $25 million as part of a class action settlement after Trump defrauded students who went to Trump University. In 2018, the New York Attorney General sued Don Sr., Don Jr., and Eric for malfeasance in the administration of Trump's charitable organization. And as part of that settlement, they agreed to dissolve the Trump Foundation. And in 2022, quote, the Trump Organization and the Trump Old Post Office LLC entered into a settlement agreement with the Office of the Attorney General for the District of Columbia, arising out of allegations that the 58th Presidential Inaugural Committee paid excessive fees to the Old Post Office LLC that accrued to defendants' benefit. Yeah, so in other words, the Trump defendants have a long and documented history of committing financial fraud in New York State, and they can't be trusted with running any type of business or charity. I don't know how many times we have to keep doing this. But Judge Engoron's decision not to cancel the certificates nor impose a permanent ban on Trump and the other executives probably takes away some good arguments he might have had on appeal. And it's going to be tougher for Trump to prevail on appeal because the Court of Appeals gives a lot of deference to credibility and factual determinations made by the trial court judge. Generally, these findings can only be overturned on a finding of clear error. And generally, there's only clear error if a judge didn't cite any evidence for factual findings or something similar like that. Judge Engoron supported each of his conclusions with witness testimony and documentary evidence. The Court of Appeals doesn't like to substitute their own judgment for the person that was actually the fact finder in the trial. So the bottom line is this verdict might have caused Trump to lose his appetite, but luckily he can get it back with today's sponsor, Factor, and maybe lose a few pounds while he's at it. Because Factor makes meeting your nutrition goals easier than ever by delivering fresh, never frozen, dietitian-approved meals right to your doorstep. And the meals are completely ready to eat in just 2 minutes. You can eliminate the hours it would take to shop, meal prep, and cook so you can spend your day doing the things you actually want to do. You'll have over 35 different options a week to choose from, including keto, calorie smart, vegan and veggie, and more. And there's even more to enjoy with over 55 nutrition-packed add-ons that help you make your weekly meal planning even more delicious. Factor meals arrive pre-prepared and ready to eat in just 2 minutes. In the same amount of time I could even think about going to the grocery store, my Factor meal is already done. Because sometimes I just want a good, healthy meal without having to cook, and it's surprisingly affordable. And now Factor also offers Gourmet Plus meals as part of your weekly options. Gourmet meals like Surf and Turf or Surf and Surf, shrimp and salmon, or you can relish the best of winter and spring flavors. All the options are extremely delicious, like bruschetta shrimp risotto, green goddess chicken, and grilled steakhouse filet mignon, ready in just 2 minutes. You can choose your favorite meals or let Factor craft your order based on your taste preferences and meal history. Plus, Factor is flexible for your schedule. Get as much or as little as you need by choosing 6 to 18 meals per week. Plus, you can pause or reschedule deliveries anytime. So head to Factor75.com or click on the link below and use the code LegalEagle50 to get 50% off your first Factor box and get 2 free wellness shots with each order for life while you're an active subscriber. So just click on the link below and use the code LegalEagle50 for 50% off your first Factor box and free wellness shots for life. After that, click on this box over here for more Legal Eagle, or I'll see you in court.